What's up, y'all? I'm the Armed Educator, and today I wanted to go further into detail on a Supreme Court case that I mentioned in a previous video. That case being U.S. v. Miller. This case is rather interesting because people who are both pro-gun and anti-gun both cite this case and claim that it affirms their view on gun control. Normally, I'd say that the truth is somewhere in the middle, but that definitely is not the case here. I'm thinking about starting a series where I discuss important Supreme Court cases in regards to the Second Amendment, so if you want to see me tackle more SCOTUS cases, please like, comment, and subscribe. With all that said, let's talk about U.S. v. Miller. First, let's talk about the case's background. It all started with the passage of the National Firearms Act of 1934. I've discussed this law in a previous video about pistol braces, but I'll go ahead and re-explain it for those who haven't seen it yet. The NFA placed heavy restrictions on certain firearms such as short-barreled rifles, short-barreled shotguns, machine guns, and more. These restrictions included mandatory registration, permission from your state's attorney general, and a $200 tax.
You're ugly, you're disgusting, I'm gonna kill you, give me $200.
Something of note, $200 in 1934 is equivalent to $4,553.87 today. Thanks, inflation. We are going to focus on only one of these restricted firearms types for this case, which is the short-barreled shotgun, or SBS for short. The ATF defines them as any shotgun having a barrel or barrels of less than 18 inches in length, or a weapon made from a shotgun if such weapon is modified, has an overall length of less than 26 inches, or a barrel or barrels of less than 18 inches in length. Leave it up to the ATF to make something so simple, so complicated. So now that we know the law, we can now talk about Jack Miller and Frank Layton. Miller was a member of the O'Malley gang and was known to run moonshine and was responsible for several bank robberies. Layton was also a small-time crook that resided in Claremore, Oklahoma. After the disbandment of the O'Malley gang, Miller quickly found a new partner in Layton. This dynamic duo were transporting a double-barreled sawed-off shotgun from Oklahoma to Arkansas in 1938. The barrel was shorter than 18 inches, so they were in violation of the NFA since it wasn't registered, the $200 tax wasn't paid, and they didn't receive permission from Oklahoma's Attorney General to own it or Arkansas's Attorney General to bring it in. Miller and Layton were both suspected criminals, so the government had been following them for a while. When they were found in possession of the SBS, they were instantly arrested and indicted.
Right to jail, right away.
In early January of 1939, Miller and Layton's lawyer, Paul Gutenson, filed two separate demurs to indictment, which is a fancy lawyer term that means these charges are bogus because the law is bogus. In the first 1.5-page long demur, the duo's lawyer claimed that Miller and Layton's Second Amendment rights were being violated. In the second, they made claims that the Commerce Clause was being violated. Judge Hartzell Ragan, who presided over the Western District of Arkansas, agreed and approved of both demurs. The Attorney General to the United States decided to skip over the Eighth Circuit and appealed directly to the Supreme Court.
Boy, that escalated quickly.
On March 30th, 1939, the Supreme Court began hearing oral arguments. Gordon Dean and his team were assigned to represent the United States. There was only one problem. The legal team representing Miller and Layton were no-shows. Frank Layton and Jack Miller disappeared almost immediately after the demur was approved by Judge Ragan. Neither Layton nor Miller paid Gutenson, so he withdrew his services. From what I understand, Gutenson was glad to be rid of the pair.
See you, chump.
So for almost an hour, the government circle-jerked around and ultimately decided that the National Firearms Act, in respect to its regulation of short-barreled shotguns, was constitutional. The official decision was announced on May 15, 1939, a little over a month after the hearing. Clark McReynolds says in the unanimous decision, "In the absence of any evidence tending to show that possession or use of a shotgun having a barrel less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument." They specifically say that there is a lack of evidence to show that a short-barreled shotgun would be effective in militia service. This absence of evidence shouldn't have come to anyone's surprise. With little to no discovery in the original trial, no arguments presented by the defense, the Supreme Court really had no choice but to side with the United States. The only documents the Supreme Court could look to consider the argument for the defense were the pair of 1.5-page demurrers. To put that in perspective, the script for this video is about 8 pages long, and this video will probably be around 15 to 20 minutes in length. Let's go ahead and think about how trials actually work. If there isn't enough evidence to convict the defendant, they are then rendered not guilty. In this case, the NFA in relation to short-barreled shotguns was on trial. The court did not find enough evidence to convict, so the law was upheld as constitutional. The question at hand is, how did the Supreme Court reach this decision? What evidence did they actually consider? What logic did they use to determine that short-barreled shotguns weren't protected under the Second Amendment?
What was the reason? What was the reason? What was the reason?
To answer that, we're going to look at the text of the opinion itself. McReynolds says, certainly it is not within judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. What is the common defense, you might ask? Well, that is best answered when you look at the Constitution. One of the purposes of government listed in the preamble is to provide for the common defense. And later in Article 1, Section 8, Clause 15 and 16, they say, Congress shall have the power to provide for calling forth the militia, to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. The militia has been defined in Title 10 of the U.S. Law Code, Section 246, to be every able-bodied male aged 17 to 45. There are two classes of the militia: the organized militia, consisting of the National Guard, and the naval militia, and the unorganized militia, sometimes referred to as the reserved militia, who is everyone who is not part of the organized militia. So that means we're all part of the militia in some fashion. So remember that next time someone asks you what well-regulated militia you belong to. Let's get back on track. We were talking about the common defense. Should the nation need to defend itself, the militia would come to aid the effort. As McReynolds puts it, when the militia is called for service, these men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. Let's tackle the first important phrase, supplied by themselves. Notice how it doesn't say supplied by the government or supplied by the state. The people are expected to show up with their own arms that they actually own. In fact, the Militia Act of 1792, which was passed a year after the Second Amendment's ratification, enrolled all free white males aged 18 to 45 to the militia, and it required that those enrolled must provide their own muskets, powder, bayonets, and a bunch of other support gear. You might have noticed that this law only applied to free white males.
That's racist.
Obviously, the 13th Amendment that abolished slavery and the 14th Amendment and its Equal Protection Clause were not yet part of the Constitution, so it stands to reason that this law wouldn't be considered constitutional, which is why it was replaced by multiple militia acts since the Reconstruction era. The last significant update to the militia law was the 1858 Act. The actual text was shown earlier in 10 U.S.C. 246. The ability to raise a militia is one of the most important reasons for the amendment's existence in the first place, though it certainly isn't the only one, as elaborated in D.C. v. Heller. You cannot have a militia for the common defense if the people do not have the right to keep and bear arms in the first place. We also need to understand why the founders saw the need for people to be armed to serve in the militia. They had two reasons for this. They feared a standing army, and they believed the militia was the best way to defend a nation. McReynolds cites Adam Smith's Wealth of Nations in the Miller decision. It is there said, men of Republican principles have been jealous of the standing army as dangerous to liberty. In a militia, the character of the laborer, artificer, or tradesman predominates that over the soldier. In a standing army, that of the soldier predominates over every other character. In this distinction seems to consist the essential difference between those two different species of military force. The nature of the military structure places the military power over the civil power, while the nature of a militia places the two on equal standing. As far as it being the best defense, I could dive into several sources that demonstrate the strategic advantage of militias as opposed to standing armies, but I'm starting to get off track from Miller. If you want more information on that, I would check out constitutionalmilitia.org. They have a lot of great information and resources there. For the second important phrase, we will focus on common use. If the common weapon that people owned at the time were rifled muskets, the people would bring rifled muskets when called. The same logic applies to bolt-action rifles and semi-auto rifles. Now, the extent of what it means for a weapon to be in common use wasn't really expanded upon until DC v. Heller in 2008, and further so in Catano v. Massachusetts in 2016, but the argument that the United States made in the Miller case was that the weapon should be commonly used by militias and militaries around the world. Since there was a lack of any evidence of militias and militaries using short-barreled shotguns, the Supreme Court presumed that they weren't in common use and therefore determined that they were not protected by the Second Amendment. Of course, the court's not going to find enough evidence to suggest they were in common use. Let me remind you, there were no arguments presented by the defense, and there was little to no fact-finding in the original trial. The Supreme Court just looked at the empty table where Miller's lawyers would have sat and said, "Show me the evidence, show me the evidence." So what does the common use phrase mean in today's terms? Well, there are two schools of thought. The first school of thought regards weapons that we already own with little restrictions. Today, a majority of people own semi-automatic weapons, which are not subject to the NFA's restrictions. One could also conclude that they are in, common use. In 2020, the National Shooting Sports Foundation reported that they were an estimated of 24.4 million AR-15s in circulation. I'm sure the number has grown significantly since then. And by the way, this number is not even counting other semi-automatic platforms analogous to the AR-15. In Catano, the court determined that because there were around 200,000 stun guns used for commonly lawful purposes, they were considered to be in common use. Last I checked, 24 million is a little bit more than 200,000.
2 + 2 is 4, -1, that's 3, quick maths.
Under this school of thought, if the militia were to be called, the people would supply their own semi-automatic rifles and handguns. The logical conclusion is that a commonly owned weapon, such as the AR-15, is protected, while gimmicky or non-conventional weapons analogous to the Glong might not have the same level of protection. Though it would be hilarious to think of someone bringing a Glong into a war zone. The second school of thought, briefly entertained by Scalia in the Heller decision, involves the guns commonly used by militias and militaries around the world. Every modern military uses fully automatic weapons. One could also conclude that they would be very effective in the common defense. Therefore, machine guns and most other Class 3 firearms should have extended protection, resulting in deregulation and removal from the NFA. Since machine guns weren't the topic of discussion in the Miller case, the court couldn't bother to consider the question. So there have been absolutely zero legitimate challenges to the actual meat of the NFA since it was passed in 1934. With all this talk about militias and its relation to the Second Amendment brought up by the Miller decision, a new Second Amendment theory was born. You might have heard some people call the Second Amendment a collective right, or it is the right of the militia to keep and bear arms. Both are completely false and dishonest looks at the historical tradition as well as the plain text of the Second Amendment. But if you're a history geek like me, one thing you will learn is that there is absolutely zero historical documents, legal reviews, or constitutional analysis that mention anything resembling a collective right or a militia right from before the 1940s. Though I can point you to several that confirm, or at the very minimum, allude to an individual right. Nerd! Whether you view Miller in a positive light or a negative one, we should understand that it doesn't completely contradict what most Second Amendment advocates have been saying since the beginning. If anything, it reinforces it. Here's the hard-to-swallow truth for the anti-gun lobby. Weapons of war have always been the point of the Second Amendment. So, as you have seen, this case is not a legitimate challenge to the National Firearms Act. A half-hearted defense was presented, little to no discovery actually happened, no arguments were presented by the respondent's counsel. The portion of the law that was under review was probably the hardest to challenge with the logic that was ultimately applied. The only documents the courts could consider were the pairs of 1.5-page long demurs that weren't really written with any true conviction. To make this case even more suspect, it is very likely that Judge Reagan was colluding with the federal government to provide the perfect case to uphold the NFA. By the mid to late 30s, people began to question the constitutionality of the NFA and a new law known as the Federal Firearms Act of 1938. Miller was the perfect storm for silencing the critics. Brian Fry said it well in his 2008 article about the Miller case. A prominent Democrat, Reagan endorsed Roosevelt in 1932 and helped push the New Deal through the Ways and Means Committee. In return, Roosevelt made him a district judge. The NFA was part of Roosevelt's New Deal program, enacted with broad support shortly after Reagan took the bench. But the Federal Firearms Act of 1938 was stirring up popular opposition. much of it based on the Second Amendment. The government needed to silence the complaints, and Miller was the perfect vehicle. Reagan had presided in an O'Malley prosecution, so he knew Miller was a crooked, pliable snitch who wouldn't cause any trouble. And Gudinson was a comer who knew the game and got his due. Reagan's memorandum opinion presented no facts and no argument. With no defense muddying the waters, it was the government's ideal test case. I'll include a link to that article down in the description, as well as the various documents I was able to find in regards to this case. A big thank you to 2A History on Twitter for pointing me towards the article. Go ahead and give him a follow and tell him that the Armed Educator sent you. Considering all these facts, I have reached a rather damning conclusion. If this is the case that upholds the NFA as constitutional, I've got to say, I'm not impressed. I hope to see actual legitimate challenges to the NFA in the future. This case is just too much of a tease to be the only case ever to challenge it. With that said, if you think the NFA is blatantly unconstitutional and should be struck down, you have found the right channel. So go ahead and subscribe. And while you're at it, leave a like and comment what Second Amendment SCOTUS case you want me to tackle next. You guys are doing the most in helping me reach a broader community, and I can't thank you guys enough for that. That's all I have for you guys. So until next time, be sure to stay armed, stay educated. Thank you.